Joining us on the line now is Catherine Grant Makokera. She's the head of economic diplomacy at the South African Institute of International Affairs. Catherine, thank you so much for making the time to join us. It seems as if Minister Davies has been reassuring investors for quite some time now. Would you say the handling of these bilateral trade agreements has been a diplomatic mess?
I wouldn't go so far as to say it's been a diplomatic mess, but it is correct to say that this has been a process that has been ongoing for, in fact, a number of years now. And I think that the timing has been an issue. The bilateral investment treaties were cancelled before the Foreign Direct Investment Act or bill was tabled only last Friday. That created a sort of a policy vacuum, if you like, where investors were slightly uncertain as to the direction South Africa was taking in terms of protection of foreign investors.
What are the key points in terms of the differences that the new bill is likely to have that the bilateral treaties didn't afford investors before?
From what we can see, the initial reading of the bill is that there's not much protection offered for investors in the bill. It does in fact seem to take away the option to international arbitration or dispute settlement. This is not specifically mentioned in the bill. It's really quite an artful piece of drafting. It's created a sense of constructive ambiguity. As to what are the options for investors in terms of if they exhaust all of the domestic court processes. So that's one challenge that I think is in the bill at present. There are two other points that I think are worth noting. One is that the bill sets out a very wide definition of what would be public interest. And public interest is a reason to sort of restrict the rights of investors. And in the case of this bill, it almost covers anything you can think of. I think that that's going to be a bit of a challenge as the bill goes before public comment phase and then into Parliament. That could in fact prove a at international law level as well. And then the third point is the definition of expropriation. The definition of expropriation in the bill seems to be very narrow, and this needs to be looked at now, particularly in light of a constitutional court case ruling that was made earlier this year on the issue.
Let's look at the international arbitration clause that's in the bill. How important is it for investors to know that they have direct access as a first point of call to an international court when they come into disputes in a domestic market?
I think most investors would not resort to international dispute arbitration as the first option. Most investors look at the judicial system that operates at a domestic level when they're deciding whether to put their money into a country or not, because that is your first point of call. And certainly the draft bill outlines that. And South Africa has got a fairly robust judiciary. So I do take Minister Davies' point that there are options at the domestic level for investors. There is, however, a point to be made that once you have exhausted all of the domestic options, there should be a further independent step that could be taken by investors. That is not currently in the draft bill.
Of course, as you've already raised, probably one of the really sticky issues is the state seizure of assets and how that's not clear in terms of the finite definition of expropriation. Again, do you think that this is a significant factor to deter investors?
I don't think so. I don't really think that there's a massive threat of expropriation in the South African context. This has certainly been put to bed a lot by the dampening of the nationalisation debate that we saw a few years ago. So I think that what's going to be important is to see an alignment of the definition around expropriation with existing case law, with existing pronouncements by the Constitutional Court.